My name is Douglas Elliott. I'm a partner in the law firm of Roy Elliott O'Connor in Toronto, and I have been a very active Charter of Rights lawyer. The legal community that was working on this was fairly small and essentially centered in Vancouver and Toronto. There were a few lawyers in other parts of the country that were working on this, but very few in Montreal, for example, because Quebec had very early had human rights protection under the Quebec anti-discrimination law, and so people could go to the Human Rights Commission there for relief, and so no private bar dealing with these issues ever really developed much in Montreal. So the bench strength that we had really was in Vancouver and Toronto. But there was only about maybe half a dozen or so lawyers in Vancouver working on these issues, and a similar number in Toronto. We all knew each other. We talked all the time. Once the internet came along, we used to communicate by email. So we were able to consult. And Ontario, the other thing that helped us was that Canada had only one national LGBT organization. It actually wasn't even around until the 90s, EGAL. But once it started to grow and flourish, there was only one, there weren't competing organizations, there was only this one national organization. Plus we had the Canadian AIDS Society, which was a great ally. We also had some allies in other sources like the union movement. The unions were incredibly supportive in a lot of the cases that we did, especially a lot of the early cases were done by unions, but for example in the Mark Hole case, the Canadian Auto Workers Union and the Canadian Union of Public Employees intervened as part of the coalition in support of Mark Hall. So it was, there was some diversity, but at the core there was this group of 12, 15 lawyers who worked on these cases together, got to know each other. There was a high level of collegiality, a high level of trust, and a very well-articulated communication system. I mean, if there was an important case coming up, it wouldn't escape my attention or Joe Arve's attention in British Columbia, or Ken Smith in British Columbia, or Cynthia Peterson, or Kathy Leahy in Kingston. I mean, people knew who to get in touch with and to consult, and we would try and make sure that the clients were well represented, and that if there were organizations that could be involved that could help, that we would approach those organizations about getting involved to assist with a particular case. Same-sex marriage, the plot for same-sex marriage was hatched in 1999. Coincidentally, Professor Rob Wintermuth of King's College London organized the first major international conference about same-sex relationships in 1999, and a number of us attended that conference. In fact, Justice Claire Litteridge-Bay of the Supreme Court of Canada also attended that conference. M versus H was hot off the press. A lot of people were talking about it. But at that point, the debate about where same-sex marriage was going to unfold first was about, will it be in the Netherlands or will it be in the United States? And the Canadians began talking, and we said, well, maybe it won't be Canada, maybe it won't be the Netherlands or the United States, maybe it'll be Canada. Maybe Canada is finally ready. It's really the main issue that's left on the table. Do we think it's possible? And we started to have discussions over drinks and lunches, and we thought, maybe it is possible. And we approached some of the people working on the issue in the Netherlands and the United States and asked them for their views and their input and their help. And they agreed to help us and to talk to us. And in particular, Evan Wolfson, who's been the guru of same-sex marriage in the United States for many years, and who, incidentally, I had actively discouraged from promoting same-sex marriage in Canada prior to M versus H. He agreed to help. And there was a conference in Kingston that fall, and he agreed to attend and to meet with us. And on the train back from Kingston to Toronto, Martha McCarthy and myself and Evan plotted our strategy for same-sex marriage in Canada. And a part of that strategy was that I was going to represent the Metropolitan Community Church of Toronto, so that we made sure that this was not about the gays versus God, that we made it clear to the court that there were differing religious perspectives on marriage, and that one of those religious perspectives favored same-sex marriage. So that was the beginning of it. We also knew that we, of course, would want our colleague Cynthia Peterson involved for EGAL, that EGAL was going to have to be part of this, and that there might be other community organizations involved, but the three kind of key players would be Martha, on the legal side would be Martha, myself, and Cynthia. That's who we thought was would be the core Ontario team. We also felt that we knew that there was a case that was underway in Quebec. I had met the Quebec Council, and I didn't think the Quebec case was strong or strongly led. The clients, the couple, Michael Hendricks and Renee Leboeuf, were fantastic. They were excellent. But the case was not well conceived. It was in trouble. They had made some tactical errors, in my view, and so we didn't think Quebec was the place to go. BC was the main competition for Ontario, but we felt as Ontario lawyers that the Ontario courts were ready, that they were ready for a same-sex marriage case, and we thought the Ontario public was also, if not ready, close to ready. So we put together the strategy. And Martha was going to, Cynthia was going to represent EGAL, I was going to represent Metropolitan Community Church of Toronto. Martha was representing a group of couples. Hetty Halpern from Windsor was the one who ended up being the lead plaintiff, and so her name is on the case. But there were a whole diverse range of couples that she had there, including Michael Leshner, who's a well-known activist. The case in BC, we had a discussion, and EGAL decided they wanted to push the case in BC first because the NDP government there was supportive. That turned out to be a disaster because it was the only case we actually lost in front of Justice Pitfield. He actually even awarded costs against EGAL in that case. It's just frightening the way that case turned out initially. But we won the first Ontario case, and then all of the cases after that were successful. We ultimately, in June of 2003, won the Halpern case in the Ontario Court of Appeal, and the most remarkable part about that ruling, apart from the fact that it was Roy McMurtry, the Chief Justice of Ontario, who was presiding, and he was one of the architects of the Charter of Rights. As I said to my American colleagues, it would be like arguing a legal case in front of Thomas Jefferson about the Declaration of Independence. So when that case came down, they said same-sex marriage definition changes immediately. Previously, the court rulings had given the governments 2 years to respond, but this one said two things. It said people can marry immediately, number one. Number two, it said those marriages that took place back in January of 2001 at this Metropolitan Community Church of Toronto are valid marriages. So same-sex marriage was an instant reality in Canada in June of 2003. The government had to respond. They met in caucus in North Bay in July. It was an impassioned debate. I understand there was a lot of tears and some very personal statements made by gays and lesbians who were part of the Liberal caucus arguing in favor of same-sex marriage. And at the end of the day, Prime Minister Chrétien said, well, we're Liberals, we have to go on the side of equality. And he supported his Attorney General, Martin Cochon, who had decided no appeal, we'll have a bill, we'll have a reference to Parliament. And so we continued to litigate in the various provinces, though, because we weren't sure that that was going to happen. And we wanted to belt and suspenders, you know, we wanted the protection of court rulings in every single province while the political process was unfolding. We also knew that Stephen Harper, as leader of the opposition forces, now then called the Reform Party, was dead set against same-sex marriage. He was growing in popularity, and if he got in, we might face no bill, and maybe even the notwithstanding clause. So we continued the public relations campaign. that was being run by the coalition led by EGAL. We continued the litigation. We continued to try and win over the hearts and minds of Canadians. The male couple that were married at a Metropolitan Community Church of Toronto, Kevin Barassa and Joe Varnell, were in the media constantly. They had a fantastic website, samesexmarriage.ca, that they kept up to date with all of the information about the court proceedings and everything that was going on. So it was a real effort to reach out to Canadians on this issue. And it really was working. We could see support was generally growing, despite the fact that there were some setbacks. After the Ontario Court of Appeal ruling, there was a huge backlash against us, including a statement from the Vatican against it, and the Catholic Bishop of Calgary saying that the Prime Minister was going to go to hell, and various Catholic MPs being refused communion, like in Mass. They were being denied the host. I mean, it got really ugly. But we managed to win over public opinion, and we went on the reference, and the reference was amazing. There were so many lawyers there, for starters, that the courtroom practically didn't have enough room for all of the lawyers. It was amazing because for the first time the federal government was standing up on our side. They were there represented by Peter Hogg, the most preeminent constitutional lawyer in the country, saying that this was the right thing. Everyone was filled with a sense of the history of the moment and how important it was. And then, of course, when the ruling came down, similarly, there was electricity in the air. It's the first time I've seen TV studios allowed to be set up in the lobby of the Supreme Court of Canada. We were ushered in advance to the clerk's library of the Supreme Court of Canada to read the decision quietly. We couldn't have any cell phones with us. It was all like top secret, you know. It was very exciting. And then we came out, and of course it was successful, and it was very well received. But we still had to get the bill through Parliament.